Ladies and gentlemen, hit subscribe to this channel right now. There are 4 major victories, the fifth coming in a couple of months, or less than that, a couple weeks. But there have been 4 major victories, a fifth on the way, for President Trump from the Supreme Court in the past couple of months. Hit subscribe. In a couple of seconds, you will hear a brilliant rebuttal by Solicitor General John Sauer at the Supreme Court, ensuring that President Trump and his administration get an end to these nationwide injunctions. His administration has experienced more of these injunctions than any other president. And the reason is that Democrats can't go through Congress, not because they don't have it, but because they don't want to legislate. They're not even running on individual bills or legislation to protect undocumented immigrants who are accused of committing crimes from being deported. They would never run on that. They want to go through nationwide injunctions, which, by the way, AOC and Ron Wyden opposed just 2 years ago, and Democrats opposed. Even Justice Elena Kagan opposed nationwide injunctions. We talked about that on this channel. But really quickly, and you'll hear this wonderful dialogue between, I believe it's Barrett and then Justice Jackson and Solicitor General John Sauer. It's absolutely amazing. But here, the Supreme Court allowed President Trump to reverse Biden-era policies pertaining to immigration. Supreme Court defended DOJ. Supreme Court allowed President Trump to fire anyone he wants to in terms of top officials in the executive branch just recently. And here you have Supreme Court boosts Trump administration deportation plans under Alien Enemies Act. That's the first decision on the Alien Enemies Act, which gave Trump the ability to end judge shopping, a certain aspect of judge shopping. But check this out, ladies and gentlemen. This is really interesting, and it's a brilliant rebuttal by President Trump's legal team, the Solicitor General, on why these nationwide injunctions need to be stopped. So you had 4 major victories in the past two months or so. And even if the Supreme Court eventually sided with the lower court regarding the Alien Enemies Act, the initial victory allowed President Trump to end a certain aspect of judge shopping, which was very important. So these are 4 major victories, a fifth on the way. Check this out.
Difference to you. Do you want to say anything about whether there's a practical difference between a universal injunction and a loss in the class?
Absolutely.
Okay.
Among many others, the represented class members are bound in the class action context. And that means that if they lose, they're bound by that as well. So they're taking a grave risk, so to speak, by proceeding through a class action. And it has this symmetry where the government is bound if we lose, they are bound if we don't lose. And that's a very important distinction.
And you would respect that judgment?
If it were a judgment, now we may try to litigate in other contexts and try and get a different judgment from a different district court, but we would be bound by that judgment, as would they, and that's the crucial point.
Okay.
Justice Jackson?
So as far as I can tell, your bottom line seems to be that what you call universal injunctions give relief to non-parties without going through the necessary steps, which you identify in Rule 23. Do I have that right? I mean, is that sort of like boiled to bare essence what you're saying?
I would say there's a lot more to it, but that's one very important point.
That's a key point that I want to focus in on for a moment. I guess I don't understand why you are saying that these kinds of injunctions are giving relief to non-parties. First of all, I think they can be also easily characterized as focusing only on the defendant pursuant to the court's jurisdiction, personal jurisdiction over this person relative to the subject matter jurisdiction that the court has, and the relief is telling the defendant, stop doing this thing that the court has found to be unlawful.
Did you know?
Rather than characterizing it as a quote-unquote universal injunction, I think one could easily see that this is just about the extent to which the court can constrain a defendant over whom it has personal jurisdiction. Can it do so completely or just partially with respect to, just say stop with respect to this plaintiff? Am I I don't understand where this idea of universal injunctions comes from in this context.
I think the relevant distinction is an order. That order is, in this case, the government defendant to cease allegedly unlawful activity as to the parties who have come into court and sued, and one that says to the government defendant, cease the allegedly lawful activity against everyone in the entire world.
No, just cease it. Just stop. This executive order, we do this in the APA context all the time, right? The statute says you you set aside the conduct, right? That it's unlawful. And we don't really parse it out and say, okay, but it's unlawful only as it applies to the plaintiff or not. So it's a very common concept for the court to enjoin a defendant from doing particular unlawful behavior. And what you're now asking us to do is to require that the court have an additional limitation in its order that says you only have to stop doing this with respect to the plaintiff. And that's the part that I don't understand. I guess, from what I can read from your papers and what you've said here, that limitation you say comes from this principle that if you don't do that, you would be somehow giving relief to non-parties. But I wonder if that's right. It seems to me that the relief is the judgment that you provide to the plaintiff that says stop doing this conduct. And you give it only to the plaintiff. That's where the limitation comes. The plaintiff is the only person who can go to court after you violate this order and enforce it. Other people are incidental beneficiaries of a court ordering you to follow the law.
Or they're not beneficiaries. Or lower courts are wrong, which routinely takes place. Apparently, lower courts who blocked Trump were wrong about the legal protections from the Biden era. Federal courts were wrong about DOJ when they backed Democrats against Trump regarding DOJ. Apparently, they were wrong when federal courts tried to stop President Trump from firing people within the executive branch. Apparently, they were wrong initially about the Alien Enemies Act. Federal courts are routinely wrong. Okay, federal courts, the state Supreme Court of Colorado was wrong. Were they breaking the law or were they upholding the law when they found that Trump was committing a rebellion and trying to stop Trump from being on the ballot nationwide? Apparently, Jack Smith was breaking the law when he tried to imprison Trump, and Democrats were breaking the law and were acting in an unconstitutional manner when Democrats were trying to imprison Trump with a special counsel. Okay, and they ruled that presidents have immunity, rightfully so they can actually be presidents. They can actually perform a speech without Democrats hyperventilating and trying to imprison them for claims that they believe are baseless, while they then accuse Trump of being a Kremlin operative and usurp Biden after he won his primary with the vice president. So let's listen to the rebuttal here. John Sauer is going to say, well, yeah, but the lower courts aren't always right.
That's like everyone in the world. When the court says follow the law, anybody who would have been hurt by your not following the law benefits. Okay. I don't understand why that would limit the court in its ability to tell you, don't do this unlawful conduct.
Two responses to that.
Yes.
There's a lot there. Two responses to that. One is that principle that your question referred to is the holding of the court in Worth against Selden, and it's reaffirmed in Gill against Whitford, in Lewis against Casey, and similar cases, that the authority of the federal court, whether it's viewed as arising under Article 3 or under its traditional scope of equitable authority, is to remediate the injuries to the complaining party. And then to address your question about...
Can I just stop you there? I'm, as the court, remediating the injury by telling the defendant to stop doing this behavior. The plaintiff has brought a claim that this executive order is unlawful. I litigate it, and I say you're right. Stop doing it. You cannot enforce this order. So I don't understand why that's like outside the scope of Worth versus Selden.
If the court in that case is imposing what we've called an indivisible remedy, for example, vacator under the APA, there's a debate about what set aside means. Assuming it means to vacate, then the remedy that Congress has provided as a condition of its delegation to the agency is if one part of the, if the regulation is unlawful, then the remedy granted, which directly remediates the plaintiff's injury on that hypothetical, is an indivisible remedy that benefits others. Here in this case, and in all the other 40 cases, we see something totally different.
Yeah, I understand.
It's not necessary to remediate the injuries of the plaintiff before them. That is the
I understand. Let me just turn.
So Justice Jackson agreed with General Sauer eventually on an important aspect of that topic. The universal injunctions are meant to for Democrats to legislate, but if Democrats want to legislate, they go through Congress. Problem is they don't believe in their alleged value system or their policies. They were keying Teslas and then talking about the fate of the world and the planet and the climate. Doesn't make any sense. They are pontificating about people being sent back to countries that they were born in. The problem is they don't want to pass any bills. They're not running to take over the House in 2026 on legislation that would protect undocumented individuals who are accused of crimes. So they're all for public relations stunts and going through the courts. But now they can't do that because universal injunctions will be severely limited or ended. Hit subscribe. This channel is huge. I'll be back in a couple of hours.